All right. Good afternoon, everybody. A nice, busy morning so far. We had my regular morning routine, doing some work, and then Friday, sometimes I'm able to jump on the ice. So we were able to get in a hockey game this morning. Nice skate this Friday morning. And then after that, we went on to the Grace Curley show, and that was being hosted by Mike Crawford. Spoke about Kelsey Fitzsimmons' case and Turtleboy. We only had a couple minutes to discuss it, so we couldn't really get into the details, too many of them at least. But that was fun. First time that I've spoken with Mike. I told him my first comment on the show was surprised that we've been covering the same cases for so long, and this is the first time we're talking. But we had a nice conversation about Kelsey Fitzsimmons' case and Turtleboy's case. It was just for 10 minutes, so we're going to have to continue that conversation at a different time. But that was the day so far. So we left off yesterday in the middle of going through Turtleboy's motion. And we got to pull that back up so we can continue. Now, remember, yesterday, first of all, just thank you, Leanna, for becoming a member. Yesterday, we went through more of the end of the motion to dismiss, which discussed a lot what happened to the grand jury, which is troubling, to say the least. So we are going to continue, and we're going to start from the beginning this time. So let's pull it up right here. And let's see. I hope you guys are all ready for this marathon. Hope you got your snacks ready. If we have to take a nap in the middle, we may do that also, but we gotta get through this. So let's do this. All right, here we go. So the first, let me just pull this up a little bit. Oh, let me blow that up. Okay, there we go. Now that should be clear for everybody. All right, now by the way, just before we get started, actually, no, I'm having a drop of a trouble here. Let me just. Okay. Yeah, just before we start even, Mark Betterow put out a nice tweet about the font that I love so much and the fact that it's 14 instead of 12 point. 14 point instead of 12 point. Apparently, and I didn't see much of this, but the haters, I guess, were attacking him for the font and perhaps the 14. So he just put out a nice little tweet there saying, you guys don't know anything. So that's always fun. All right. So the first part of the motion, he just goes through what they're asking for in the motion, which is important. You got to know what you're asking for. So he's asking really for three things. Dismissal, obviously. If not dismissal, then at least an evidentiary hearing. But disqualification of Ken Mello, for a number of reasons which we spoke about yesterday, the Brady and Giglio violations, which we're going to get into a little bit more today, and the fact that the grand jury, the prosecution's impairment of the integrity of the grand jury proceedings. So these are the three different things that he's asking for in this motion. Obviously, the most significant one is to dismiss. So let's get on with it. Mr. Carney, known by the moniker Turtleboy, and by the way, you got to love the way that he writes here, because it's just snarky enough, and it's also, the way that he frames things and, gives them the right adjectives. It's just a work of art. It really is. So let's go through it. Mr. Carney, known by the moniker Turtleboy, is a credentialed independent journalist with large platforms on social media and YouTube. He writes articles and regularly hosts live YouTube shows, which generally are 2 to 3 hours in length, and address numerous topics of public concern. Mr. Carney's YouTube videos are categorized sequentially as numerical episodes, each of which contains a unique title summarizing the contents of his shows. As we spoke about a little bit yesterday, he names his shows how he wants. Some of them are lengthy, but the point is that he names them a certain way. Episode numbers and titles of Mr. Carney's shows are displayed prominently on his YouTube page and may be viewed by anyone, irrespective of whether they subscribe to this channel. And by the way, if you're watching now, you should subscribe to Brother Counsel. After all, it's free. All it does is help me out and help the YouTube algorithm. So go ahead and hit that subscribe button. Mr. Carney's investigative reporting has exposed numerous examples of fraud, corruption, and wrongdoing. He often intersperses his journalism with elements of comedy, satire, and activism. Not surprisingly, many people who become the subject of his reporting and content don't like him. That can happen when you're a journalist and you're an activist, right? Even if you say very objective things like I've done on my channel, I get hate also. But if you take that a step further and become an activist and be in people's faces, like be a journalist, a real journalist, what journalists are supposed to be doing, getting in people's faces and asking them hard questions, and people are not going to love you so much. In April 2023, and the timeline here is important. The timeline here is great because it really lays out what happened in this case and why he was charged. In April 2023, Mr. Carney began researching the Karen Read case, which at the time appeared to be a straightforward open and shut vehicular homicide case. After he reviewed publicly filed court documents and acquired information from sources he generated, Mr. Carney quickly realized that the case against Ms. Read was far more nuanced than had been publicly reported up to that point. Since he first delved into the circumstances surrounding how John O'Keefe, a Boston police officer, ended up dead on the front lawn of fellow Boston police officer Brian Albert shortly after Ms. Read dropped him off at Mr. Albert's Canton home in her Lexus SUV, which, by the way, she has. She has the Lexus SUV back, in case anyone's wondering. Mr. Carney's reporting and content creation has centered on his unabashed belief that the Norfolk County DA's office and the Massachusetts State Police framed Ms. Read with assistance from Jennifer McCabe, members of the Albert family, and others who participated in Mr. O'Keefe's death and or helped cover it up. On April 18th, 2023, Mr. Carney published his first article. So April 18th, 2023 is when he first started on this case. I started on this case, I believe it was January 2024. So this is a good, 7 months before I started. Mr. Carney's initial Canton cover-up report was primarily outsourced by the April 12th, 2023 90-plus page court filing from Ms. Read's defense, which consisted of an affidavit from her attorney supported by numerous exhibits, including police reports and data from an extraction report of Ms. McCabe's cell phone. This is when that Google search was spoken about. Mr. Carney reported that Brian Albert, Ms. McCabe, Matthew McCabe, Chris Albert, Colin Albert, and Julie Nagel were definitely in the house at the time Mr. O'Keefe was killed, and that all of them witnessed the murder or are aware of it and have said nothing. Most of them were not questioned by now terminated and disgraced Trooper Michael Proctor. I would have loved if he wrote now terminated and disgraced former Trooper Proctor, but okay. Mr. Carney's article highlighted the Read defense's claims that Miss McCabe Googled how long to die in the cold at 2:27 a.m. on January 29th, 2022, which, if true, was damning evidence of her complicity in and or knowledge of the circumstances surrounding Mr. O'Keefe's death. Most of the individuals criticized in Mr. Carney's April 18th, 2023 article for their alleged involvement in Mr. O'Keefe's death or its cover-up later became the allegedly intimidated victims in the indictments against Mr. Carney. Now, that point can't be lost on you. Right, everyone who he all of a sudden is criticizing because of these court filings, which are coming out. And again, when this first broke about the Celebrate report showing that Jennifer McCabe Googled how long to die in the cold at 2 a.m., that was when this just blew right open. It just was blew open. And this was before, obviously, Ian Whiffen and Jessica Hyde. So all of a sudden, these people are under the gun, and it's not comfortable. So they later became the allegedly intimidated victims in the indictments against Mr. Carney. Indictments related to Mr. Carney's purported intimidation of Mr. Proctor and Sergeant Yuri Buchanan were later dismissed by the court. Those two charges against Proctor and Yuri Buchanan were dismissed by the court. We're going to see soon what happened there. Mr. Carney's well-sourced, dogged reporting and outspoken support of Ms. Read's innocence lit the spark. And look, the way that he frames this is so good. Lit the spark that quickly ignited the Free Karen Read movement, a phenomenon which galvanized worldwide support for Ms. Read and relentless, blistering criticism of the DA, MSP, and the civilians whom Mr. Carney and many others believe conceal the truth about Mr. O'Keefe's death. So all of this is important because it's all in the lead up of all of a sudden where these charges came from. So this is all incredibly important to understand how these charges came about. Mr. Carney's coverage of the Read case, which to date includes 528 Canton cover-up articles and hundreds of video episodes, virtually overnight transformed a mundane Massachusetts criminal case into perhaps the most high-profile and scandalous murder prosecution in the United States in decades. Mr. Carney's frequent reporting on the Read case has played a substantial role in the public's loss of confidence in the integrity and competence of Norfolk County law enforcement, an ongoing scandal that continues to plague the DA and MSP in the aftermath of Ms. Read's acquittal. I mean, you can't teach this. The way that he writes, you just can't teach this. It's really just great writing. And by the way, lawyers are supposed to, like, what lawyers are supposed to be I know a lot of lawyers you like to be in court, but number one of lawyers is that you have to know how to write. Like, it's so important, and that should be stressed, I think, more in law school, how to write properly. Yes, you have to learn the law as well, but you also have to learn how to write. Like, legal research and writing is so important. It's one of your first classes that you take, but it should be like a requirement to continue every single year taking another legal research and writing class. Maybe they're doing that, but research is obviously very important. I mean, lawyers are supposed to be good at research and also good at writing, and Mark's got it, but not always. You don't always see this type of writing. But for Mr. Carney's reporting, disgraced former Trooper Proctor, would still be investigating serious cases for the MSP. Other members of the MSP, including Detective Lieutenant Brian Tully, the lead investigator against Mr. Carney and Sergeant Buchanan, wouldn't have been publicly disciplined for their misconduct, and the Norfolk DA State Police Detective Unit wouldn't have been dismantled due to their misconduct in the Reed case. Now take a look at the footnote. You know how much I love footnotes. Mr. Carney's exposure of the DA's and MSP's misconduct in the Reed case has complicated the murder cases against Brian Walsh and Miles Kings, and others also, by the way. It has led to significant criticism of the DA's investigation into the death of Sandra Birchmore, which it classified as a tragic suicide, but which many believe was a whitewash. In 2024, the U.S. Attorney's Office thoroughly rejected the DA's findings and indicted former police officer Matthew Farwell for Ms. Birchmore's murder. So this is all just leading up to showing what type of job Turtleboy has done to uncover all these problems, shall we call them, in the DA's office there. So he's not getting friends this way. This is not how you get friends. But this is also protected, obviously. You're just reporting. You're a journalist. Although Mr. Carney's reporting on the Reed case raised disturbing questions about the possibility of systematic corruption in Norfolk County and gained him tens of thousands of supporters, the public officials and private citizens he has accused of wrongdoing and this is the part that had me laughing, and the microscopic segment of the population who remain convinced of Ms. Reed's guilt despite her acquittal despise him for his coverage and opinions, because they're loud, but the way that he frames is just beautiful. Microscopic segment of the population. Since Mr. Carney exposed the scandal surrounding the Reed case on April 18th, 2023, the DA, MSP, Ms. McCabe, and the Alberts have repeatedly used the criminal justice system as the instrument to silence Turtleboy and end the persistent criticism his reporting has caused and still causes them today. So they went right away. They tried to use the system, the criminal justice system, against Turtleboy. So witness intimidation charges wasn't the beginning. That's important to know. They tried to use, and this is what this all lays out, they tried to use their connections with law enforcement to get something to stick, to get silence and to do something, as we're going to see, do something about Turtleboy. The primary evidence used to secure Mr. Carney's indictments were shortened, edited, and renamed segments from his hours-long YouTube episodes, which had the effect of skewing the true context of Mr. Carney's episodes. We spoke about this more yesterday. For months prior to the grand jury proceeding, Tully and Mr. Mello were familiar with Mr. Carney's actual episodes, including their true names, length, and context. During the 2 months, and that's important also, that if they knew about it before, then they know what they're supposed to be named and not rename them to make them look a lot worse. During the 2 months prior to the grand jury proceeding, Tully and Mr. Mello welcomed unvetted evidence, in quotation marks here, for good reason, and guidance from Catherine Peter, a private citizen who they knew harbored an unhealthy obsession and hatred for Mr. Carney. Ms. Peter's dreadful credibility included incidents in 2020 and 2023 where she falsified and forged evidence to harm Mr. Carney, the latter of which included her audacious defamation and exploitation of Colin Albert and Chris Albert to further her insatiable urge. I mean, just look at this writing. You guys have to appreciate this. To embarrass Mr. Carney. Now, what are we talking about? The falsified and forged evidence? I think he's going to get into it, but the defamation explanation of Colin Albert and Chris Albert, I want to show you this for a moment. So we're just going to pull away from the document for just 1 second because I want to show you what it was. You click on that link. This is where it takes you to. So, right, so Turtleboy got this email from that email address, okay, and says, "Hi, I've been really scared to talk to anyone about this, and I know I'm not the only one, but I see that you are keeping people anonymous, and I think it's important people know. The problem that Colin Albert had with John O'Keefe was that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs with Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop from what I've heard. The whole Albert family makes money from it, and I don't know if his Uncle Brian knows or not, but I think he probably does, and explains what they are really covering up. I have screenshots of Colin selling drugs and stuff because, sadly, I have bought from him before, but I don't really want anyone to know that or know I said anything. Colin talked a lot about getting of John because Colin thought John had him under surveillance, but I don't know if he really did. He was also a huge part of bullying this girl, Erin Beatty, pretty bad. Shows what kind of person he really is. I really think what happened is he followed through with what he was saying about John. Okay, and then there's some text messages. Do you need any pure? And this is all doctored, apparently. Got the proper power, chong bit of flake if you need. Bang a bit of sniff in. Can do deals too. About all night from 8. Same banging a bit of pure and skunk. Okay. So then Aiden responded. Okay, so this is the email that was sent. Now, this was sent and later, from what I understand, was admitted to by Catherine Peter that she sent it. Okay, now, what really has me scratching my head is that that's a very dangerous email. You know, I understand that maybe she's trying to throw him something, a false lead or whatever it is, and get him to say on the show that that's what was really going on to kind of lose his credibility. I think he did mention it in one of the shows that somebody sent in that email, but then when he wasn't able to confirm it, so then he said, like with the disclaimer, I don't know who this is. I'm not sure. I have to look into it, but he didn't mention this email that he got. So that part of her plan worked, but he kind of left it alone because he couldn't confirm it, obviously. So, but what's really interesting to me is that this is someone who's now working or close with the Alberts and McCabe families. And that's a very dangerous email about, even you're making stuff up and you're trying to make them look bad, but did she have authority from the Alberts to do that? And if she didn't, so then if I was the Albert family, I wouldn't be so happy with that. Making up allegations against our kids, our son, Colin, poor kid Colin, right? He's a little kid. And you're making stuff up like that about him. And then someone's going to start talking about a show about it. Who knows how many shows he could have done about it? And then this is a person who they associate with. So I don't understand how that all works. Maybe she's not close with them. Maybe the Alberts don't like that she did that. I don't know, but it's very confusing to me. So I don't know if she's working with them or close with them or has any sort of relationship with them. But if I was the Albert family and I would see that somebody is sending those type of messages to someone who has a very large social media following who's going to maybe talk about this, I would not be very pleased. Okay, but anyway, so again, I don't know what else. I don't know what's going on there. And I don't know if she's just on her own and this is all for herself, but I don't know, it seems to there may be some suggestions that she's, close with some of these other people, but I don't know. Okay, but it's just throwing that out there. It's just, very troubling email, even if you're wanting him to look stupid, but people's kids are involved, right? Feel bad for them. Okay. Now, the falsified and forged evidence he's talking about is that fake lawsuit. I think he's going to get into that a little bit more later, so I won't spoil that for you now. Ms. Peter provided Tully and Mr. Mello with video and audio evidence, including edits from Mr. Carney's lengthy episodes, which she believed evinced Mr. Carney's intent to intimidate witnesses. As detailed in the accompanying affidavit of Courtney Healy, according to Tully, Ms. Peter directed him to specific timestamps of Mr. Carney's episodes, which he located and edited rather than review the linked files provided to him by Ms. Peter. Okay, so this is an affidavit that Courtney Healy, who works for the defense in this case, she was at some sort of meeting or some sort of something together with Tully, and she was able to sign an affidavit about this. Tully apparently renamed the edits he made from Mr. Carney's episodes, as we've heard about, and saved them in folders he created, which included at least one he named Intent, which we spoke about yesterday at length. The edited and renamed files in the Intent folders Tully created were the exact files that became the exhibits that Mello introduced and Tully described before the grand jury. Mr. Mello's direction of the grand jury proceeding made a mockery of Mr. Carney's right to due process, the cumulative impact of which impaired the integrity of the grand jury proceeding and prejudiced Mr. Carney. Mr. Mello littered the grand jury proceeding with his improper comments, his unsworn opinions of the evidence, and Mr. Carney's intent, and by twice eliciting Tully's opinion that Mr. Carney intended to intimidate witnesses. Again, we spoke about how improper that is to elicit opinions about an ultimate issue, which in this case, the ultimate issue is whether he intended on intimidating witnesses. Mr. Mello provided the grand jury with improper legal instructions, that's number one, and then failed to give appropriate limiting instructions. If you make a mistake Everyone makes mistakes, right? But then when you make a mistake, you have to correct it to the grand jury. He improperly alerted the grand jury about the possible sentences associated with the crimes for which he sought indictments, and even a charge for which he did not seek an indictment. We spoke about this yesterday. The first charge that was presented in the grand jury was this wiretapping fraud, that he was not allowed to record Scanlon. And apparently he told Scanlon he's not going to record the line, even though you couldn't hear that in the recorded conversation. And they spent an entire day on that. They spent the entire first day on Turtleboy's crime or alleged crime, which they ended up not even indicting him on, or even asking the grand jury to indict him on, or to consider. Mr. Mello dedicated the first day of the grand jury proceeding to dirtying up Mr. Carney through his introduction of irrelevant and prejudicial evidence related to an uncharged allegation of Mr. Carney wiretapping Stephen Scanlon, a topic entirely unrelated to the witness intimidation allegations before the grand jury. Mr. Mello and Tully misled the grand jury by limiting evidence of Mr. Carney's intent to Tully's edits of his episodes, which left the grand jury with inaccurate and far more incriminating information about the names, length, and context of Mr. Carney's episodes, rather than affording the grand jury access to his authentic episodes, which would have provided it with the accurate and favorable context of Mr. Carney's statements. You can't present things out of context. That's a no-no in grand jury proceedings. You can't just cut and paste and just snip certain people's comments because it's going to help you get an indictment. Now to do that, you got to present the full context. At least 28 times during the course of the grand jury proceeding, Mr. Mello elicited from Tully material false and misleading testimony about Mr. Carney's YouTube episodes, which gave the grand jury the false impression that he created the episodes to document his alleged intimidation of witnesses. Despite numerous defense demands for specific evidence from September 2024 to August 2025, that's how many they were making. A lot of demands, a lot of discovery demands, and they weren't getting anything. The DA has failed to disclose exculpatory or discoverable evidence, or at a minimum, explained what efforts, if any, it made to locate the requested evidence. So if you're not going to produce it, at least say, yeah, well, we tried, we did this, we did that, we asked this person, we called up this person, we wrote this person a request, whatever. Say what you did. And if you don't say what you did and you don't produce the documents, and this is going on from September 2024 to August 2025, there's a real problem there. It looks like you're trying to hide stuff or doctor stuff or change things or modify things, which we're going to see more about as we continue this motion. The defense made a prior defense motion to dismiss the indictments that we're familiar with without access to important undisclosed evidence that was in the Commonwealth's possession, custody, and control prior to the filing of that motion. So when we filed that initial motion to dismiss the indictments, that was filed in this case, but it was without access to a lot of this undisclosed evidence that we were entitled to and never got. Communications between Ms. Peter, Mr. Mello, and Tully, which are relevant to the instant motion to dismiss the indictment, have been in the Commonwealth's possession, custody, and control since 2023 and were the subject of specific demands on September 12, 2024, October 8, 2024, and October 17, 2024, but were not disclosed to the defense until months after the court decided our initial motion to dismiss. So all these communications, which were relevant, were not disclosed. Mr. Mello forwarded many of the communications relevant to the instant motion to dismiss the indictment to co-counsel Robert Cosgrove on December 16, 2024. So a lot of these communications were actually forwarded to Mr. Cosgrove, but Mr. Cosgrove didn't provide them to the defense until July 7th, 2025, 7 months later. Notwithstanding specific defense demands for that exact evidence addressed to both months before the defense filed the first motion to dismiss the indictment. On September 4th, 2025, the defense learned for the first time that Tully apparently edited and renamed Mr. Carney's content, and that this altered evidence later became the exhibits used by Mr. Mello and Tully to mislead the grand jury about Mr. Carney's alleged intent. Like we spoke about yesterday, just renaming them. Just renaming the exhibits. And this wasn't just one. This is 29 or something. 28, 29. That alone is a good enough basis for a dismissal on this. Or at least, at the very least, an evidentiary hearing to hear about that. Communications, and it's hard to argue that this was an accident. You know, like this is presented. This wasn't just one exhibit that was presented or two. You can say, oh, I made a mistake. You know, I renamed it for my own purposes, but we by mistake showed it to the grand jury. There was nothing intentional or nefarious. But if it's 26 or 28 or 29 of them, now it starts to look like this is not an accident at all. Communications between and among Ms. Peter, Mr. Mello, and Tully, recently disclosed by the Commonwealth, established that the defense still hasn't provided with a private video links Ms. Peter sent directly to Mr. Mello and Tully, photographs and other evidence Ms. Peter sent Buchanan, and communications between Ms. Peter and Tully regarding the assistance she provided Tully immediately before he accessed Mr. Carney's actual episodes and edited them, changed their names, and placed them in an intent folder he created for use in the grand jury. The DA now claims that numerous private links containing discoverable information about Mr. Carney that Ms. Peter provided to Mr. Mello and Tully has since been deleted by the private party, Ms. Peter, right? So if this was deleted and they did not get it because they were not forwarded it, that is not just a Brady violation that can be rectified in any other way but a dismissal. If there was evidence, very clearly, if there was evidence that was not turned over, and they cannot turn it over now because it was deleted, and they at one point had access to it, that is straight out a Brady violation that requires a dismissal. The Commonwealth has represented that Tully has never opened any unsolicited links. Now remember, this was their excuse. Their excuse was that, well, no, Tully never opened the links. So it's not like we had it. It wasn't our possession, custody, and control because he never opened them. He doesn't even know what's there. But there's a problem with that. Notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent him by Ms. Peter, but sent them to Tully for him to review. So he opened them, Mello opened them, and he sent them. So that means if you open them, that means that you saw it. If you saw it, you have a duty to turn it over to the defense. And if you don't, and now you can't get it, that's straight out Brady violation, which requires dismissal. Therefore, favorable and discoverable and evidence that indisputably was in the Commonwealth's actual possession since 2023 apparently is no longer available for disclosure to the defense. Mr. Carney has been prejudiced by the non-disclosure and or destruction of exculpatory and discoverable evidence because the defense has been deprived of critical, substantive, and impeachment evidence in support of the claim that the DA's biased and shoddy investigation relied upon unvetted and possibly tampered evidence from a source with a patently obvious motive to falsely accuse Mr. Carney and with a track record of doctoring evidence against him on at least 2 occasions. So you're not talking about someone who just harbors ill will towards another person, right? Most victims are going to harbor ill will against the person who committed the crime, allegedly, right? That can be understood. Now, not that Peter was the one that any crime was committed against, but when you're relying so heavily on this person, and this person has a track record of doctoring evidence and changing evidence, if you're any sort of reasonable police officer, you're going to look at that with a 25 grains of salt, anything that they send you. This is a person who is very embroiled in this battle with Turtleboy, hates his guts, and has a track record of doctoring evidence. And now this is the person you're going to rely on for evidence to indict him? Mr. Mello's communications with Tully and Ms. Peter regarding her relationship with and production of evidence to the prosecution, the likelihood that he will contradict Tully's claim that he has never reviewed private links sent by Ms. Peter, his knowledge of Ms. Peter's motive to falsely accuse Mr. Carney and her overall lack of credibility, his knowledge that Tully edited and renamed evidence that he later introduced to the grand jury, and his conduct before the grand jury, which included eliciting false and misleading testimony from Tully, supports Mr. Carney's defense and will make Mr. Mello an essential defense witness at trial. Mr. Mello also made himself a material witness when on November 5th, 2023, in his official capacity as Mr. Carney's prosecutor, he called the police, advocating on behalf of witness Chris Albert by seeking to have peaceful protesters assembled across the street from Mr. Albert's pizza shop charged with witness intimidation. If you didn't hear that recording yet, go to the Young Jerks and you can hear this recording where he calls on behalf of the people picketing, which makes him a witness. If you're a witness, guess what? You can't be the lawyer anymore. Mr. Mello's conduct and credibility will be the key issues at trial, and it would therefore be improper for him to represent the Commonwealth and defend himself as an unsworn witness. Mr. Mello must be disqualified pursuant to Rule 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. This court has disqualified Mr. Mello from prosecuting Mr. Carney in docket number 248, etc., for the exact same reasons being sought here. That's the Gattani charge. So the court already did this before in other proceedings, and that's exactly what this court should do as well. Accordingly, for the reasons detailed in this affidavit, its exhibits, and the accompanying memorandum of law, the court should dismiss the indictments against Mr. Carney and disqualify Mr. Mello, or in the alternative, order an evidentiary hearing on the motions because the prosecution has prejudiced Mr. Carney by intentionally impairing the integrity of the grand jury proceeding and failing to disclose this specifically requested exculpatory and discoverable evidence in their possession, custody, and control, and Mr. Mello's conduct has made him an essential defense witness. Okay, so now we're going to hear more about the background and what led up to these witness intimidation charges, because you see this as a concerted effort to get him quiet, to silence him. And they tried to use every single which avenue available to them. And then when they got nothing, Then they decided to bring these witness intimidation charges. So when we hear from Mark Betterow that Turtleboy was selectively targeted, this is where the idea comes from. When you read this, you see exactly where he's coming from. Now, let's start. On April 10th, 2023, Ms. McCabe and the Alberts learned that they were the subjects of a federal investigation into the Commonwealth's investigation of Mr. O'Keefe's death and its subsequent prosecution of Ms. Reed. On or about April 10th, 2023, Colin Albert was served with a federal grand jury subpoena. So keep these dates in mind. April 10th, 2023. On information, on information and belief on the morning of April 10th, 2023, Ms. McCabe was served with a federal grand jury subpoena. Sometime thereafter, Brian Albert, Mr. Proctor, Brian Higgins, Kerry Roberts, and others were served with federal grand jury subpoenas. On information and belief, Ms. McCabe was briefly interviewed by FBI agents on the morning of April 10th, 2023. As detailed in her testimony at Ms. Reed's 2025 trial, maybe you all remember that, you should, Ms. McCabe told at least two material lies to the FBI. Ms. McCabe lied to the FBI by initially claiming that she was her sister, Nicole Albert, before properly identifying herself, right? So when the federal agents came and they said, "Hey, are you Jennifer McCabe?" She said, "No, I'm Nicole Albert." That was the first lie. Ms. McCabe lied to the FBI about phone calls she made to Brian Albert and Kerry Roberts and others immediately after she was approached by the FBI agents. Remember, she was asked, "Who did you call in between?" Once she realized that she can't get away with this when you're dealing with the feds, they know who you are. So then she brought them back in the house and they said, "Okay, so," and they said, and she said, "I need 10 minutes. Remember that? She said, "I need 10 minutes. And then the FBI agent said, "Okay, what did you do during those 10 minutes? And she said, "I made a few phone calls." "Who'd you call?" I called, she said, Matt McCabe and the victim advocate. I think that was her testimony. And in truth, she actually made another 3 calls. Brian Albert, Kerry Roberts, and I think somebody else. I think Nicole Albert. I think those were the 3 phone calls she called that she chose not to tell the FBI about. Although she testified at Ms. Reed's 2025 trial that she was cooperative with law enforcement, Ms. McCabe terminated her FBI interview within minutes. On April 10th, 2023 at 9 a.m., on information and belief, immediately after Ms. McCabe called Ms. Roberts with FBI agents, while FBI agents were waiting to speak with her, they called Ms. McCabe lied to the agents about. Ms. Roberts asked Stephen Nelson, DA's victim witness advocate, okay, and that's redacted, and then the next few parts are redacted. On April 12th, 2023, just 2 days after Ms. McCabe had been rattled by the FBI, Ms. Reed's defense filed its lengthy motion, which, among other things, alleged that significant and reliable evidence implicated her and Brian Albert in Mr. O'Keefe's death. So you see the lead up here. You see how they're being much more under the gun now. You got Jennifer McCabe. They're getting these federal subpoenas. They're getting under the gun. They're getting visits from the FBI. Now there's this motion that's filed on April 12th, 2023. Ms. Reed's motion accused Ms. McCabe of Googling how long to die in the cold at 2:27 a.m. on January 29, 2022, and alleged that other data demonstrated that Mr. O'Keefe was inside Brian Albert's home when he died. Perhaps he's referring to the steps that he took, going up and down, and the 84 steps or something, and then the incline and declines. Ms. Reed's defense further alleged that A, it had uncovered significant evidence that Ms. McCabe had taken affirmative steps to delete and tamper with the evidence because the Google search was in a deleted state, and B, it had good faith belief that Brian Albert had taken affirmative steps to destroy evidence. After all, he got rid of his phone after some of those butt dials, right? Okay, suffice it to say that between April 10th and 17th, 2023, Ms. McCabe and the Alberts had strong reason to be concerned about their legal situation and the adverse impact on their public reputations that would result from media coverage of scrutiny they received from the FBI and or from the Reed defense allegations of their complicity in Mr. O'Keefe's death. So they're starting to get nervous. This is already in early April 2023. On April 18th, 2023, Ms. McCabe and the Alberts' concerns were amplified when Mr. Carney cited the publicly filed defense motion and exhibits as his primary source, blew the lid off the Reed case by publishing his first Canton cover-up article. So this is all leading up to his first article. They're already not feeling great, and now they have this annoying journalist who's bringing this light to everybody and using his social media platforms to do it. After Mr. Carney posted his first story about the Reed case, the DA sought to muzzle him in response to numerous complaints from Ms. McCabe and the Alberts, who had substantial access to and influence with the DA. Ms. McCabe was concerned, and this is a footnote, Ms. McCabe was concerned with being publicly associated in any way with Mr. O'Keefe's death. On January 30th, 2022 at 8:06 a.m., she Googled BPD and John O'Keefe. On February 1st, 2022, this is right after, at 11:23 p.m., she Googled John O'Keefe. On February 2nd, 2022 at 10:54 a.m., in a text message to her daughter, she said something which we cannot see because all these are impounded for some reason. On February 2nd, 2022 at 11:37 a.m., Ms. McCabe Googled Jennifer McCabe. Despite their concern with being mentioned in the growing media coverage, less than 72 hours after Ms. O'Keefe's death, Ms. McCabe and Ms. Roberts did something or said something to each other, which unfortunately is redacted. On April 20th, 2023, no doubt concerned about the viral dissemination of Mr. Carney's article and its detailed exposure of the Reed defense motion, Ms. McCabe, and again, we don't know what it is because it's redacted. On information and belief in response to Ms. McCabe something, which would become a constant refrain, the DA publicly stated it would disprove the Reed's defense allegations about the timing of Ms. McCabe's Google search. So this seems to be in response to Ms. McCabe's something, which you can imagine has something to do with maybe complaining about this Google search or saying that it never happened, taking her word for it. So the DA publicly stated it would disprove the Reed's defense allegations about the timing of Ms. McCabe's Google search. Now, that is a very tall statement. You know why? Because Celebrite usually doesn't lie. There are probably, hundreds or thousands of people that are locked up because of Celebrite, because of their data. And now under Celebrite, it said that this Google search happened at 2:27 a.m. And this was before Ian Whiffen and before Jessica Hyde. Look at this at footnote 6. Although the DA literally responded to the April 12th, 2023 defense motion, Ms. McCabe didn't demand that the DA do something until Mr. Carney's reporting emphasized her Google search and implicated her in the cover-up of Mr. O'Keefe's death. The DA's knee-jerk defense of Ms. McCabe occurred weeks before it hired a digital forensic expert, which occurred on or after May 7th, 2023. So this statement that they are going to disprove Celebrite, which is like impossible to do, they knew they were going to do that before they even hired anybody that's associated with digital forensics. The day DA Morrissey excitedly instructed his team to hire Jessica Hyde. That was May 7, 2023, because she anticipated an opinion that might support the DA's position on Ms. McCabe's Google search because of a possible time zone issue, which didn't seem to be the ultimate reason. But that's just amazing. I mean, that's just mind-blowing that they would say that they're going to disprove Celebrite, which is like almost impossible. And they attempted to do that in this case. Now, some would argue that, okay, once they got on the stand, okay, you have a question. You know, these are experts, Jessica Hyde and Ian Whiffen, and they said something and they explained why the Google search didn't happen. But how did you know they're going to say that? How did you know? How are you so confident that they were going to say that? Usually, Celebrite doesn't lie. And when I say usually, it's like 99.99999%. If there's one case where there's an issue with it, it's the Karen Reed case. All of a sudden, where Celebrite's not reliable anymore. But they knew it. They knew it from before. Notwithstanding the DA's attempt to triage the metastasizing scandal, you got to love this writing. You know, how do you not love this writing? Notwithstanding the DA's attempt to triage the metastasizing scandal by publicly defending Ms. McCabe, things continue to get worse for her and the Alberts by the day. Mr. Carney's reporting led to Ms. Reed's modestly attended court appearances becoming newsworthy events overflowing with supporters and media. Her support became so great that before both of the trials, the court ordered a buffer zone to be created to prevent jurors from being exposed to and influenced by Ms. Reed's vocal supporters. After April 18th, 2023, so we're continuing down, Ms. Reed's public support increased exponentially. Her growing throng of supporters regularly protested and held standouts, where large groups of people congregated in public spaces and displayed signs supportive of Ms. Reed and critical of the DA, MSP, Ms. McCabe, and the Alberts. On May 9th, 2023, okay, so now we're moving on. So this is all happening in April. Federal grand juries are being submitted. There's interviews with the FBI, and then you have Turtleboy picking up on the story and starting to publicize it, and now there's going to be standouts. On May 9th, 2023, the DA wrote the U.S. Attorney's Office seeking information about the federal investigation after being notified about the issuance of at least 2 federal subpoenas. On May 18th, 2023, the DA sought the recusal of the Boston U.S. Attorney's Office from the federal investigation due to what it alleged was a conflict of interest. On May 24th, 2023, Ms. McCabe and Ms. Roberts clearly worried about Mr. Carney's growing influence on public opinion because of that redacted statement there, or whatever's under that redaction. On May 30th, okay, we're continuing down into May now, 2023, Ms. McCabe unsuccessfully sought a harassment prevention order against Mr. Carney. So this is she filled out this affidavit asking for there to be a harassment prevention order against Mr. Carney. And this is May 30th, 2023. Demonstrating her fundamental misunderstanding of the First Amendment, Ms. McCabe alleged that on April 18th, 2023, the day he first reported on the Reed defense motion accusing Ms. McCabe of complicity in Mr. O'Keefe's death, Mr. Carney attacked her character in what amounted to a request for unconstitutional prior restraint on Mr. Carney, Ms. McCabe urged the court to do something so he can't blog about me. Now, this was not in the affidavit that she filled out. This was actually in the hearing. In the hearing, she asked the judge, can you just do something? Can you do something so he can't blog about me? And this was in May. The court predictably ruled that however upsetting Mr. Carney's reporting made Ms. McCabe, he was a member of the press and his activity protected speech under the First Amendment. On July 1st, 2023, Ms. McCabe, who frequently asked the DA and courts to do something about Mr. Carney, oddly contacted him on Facebook Messenger and sent him a photograph of a mostly naked man. Okay, so if you saw that, you can. If you saw that, great. Not going to show it on here because it's not great. But you can just click that link and you can see the message that, according to the motion, was sent by Ms. McCabe to Turtleboy. Ms. McCabe apologized to Mr. Carney, then ominously advised him to have fun in Mashpee, where Mr. Carney was vacationing, which suggested she kept tabs on his whereabouts, or at least knew somehow that he was there. On July 13, 2023, in an email with the subject line something, which we don't know what it is, Mr. Proctor emailed Tully, Lieutenant John Fanning, Buchanan, and Reed Prosecutor Adam Lally, referencing Mr. Carney as something. Mr. Proctor informed the group something. So it's probably not pleasant. He's probably not paying Mr. Carney a compliment, but it's redacted, so we can't really see what it says. On July 16th, 2023, no doubt reeling from the perfect storm created by the ongoing federal investigation, Ms. Reed aggressive defense, and the public's increasing awareness of the growing scandal resulting from Mr. Carney's reporting about the Reed case, D.A. Morrissey, from his personal email address, essentially begged the Massachusetts Attorney General's office, the AG, to prosecute Mr. Carney for witness intimidation and or civil rights violations. So this is from his personal email address. Now, if you take a look, you probably saw that email before, but if you take a look at number 7 here, under MGL 66, section 15, it is a crime for a public official to remove or attempt to conceal the discovery of records that are subject to public inspection under FOIA. So, just letting everybody know there that that was illegal. On July 21st, 2023, D.A. Morrissey, from his personal email account, again urged the AG to act against Mr. Carney. On information and belief, the AG declined to prosecute Mr. Carney because it recognized that it was inappropriate to prosecute him for witness intimidation based upon his reporting about witnesses who were upset after being accused and publicly filed court documents of complicity in a high-profile murder. So they tried to get the AG involved. So you're seeing the lead up here. Well, that's the important part here. You're seeing all the attempts to silence him. So there was this lead up. They tried to get the AG involved. Come on, press something against him. Civil rights violations, witness intimidation violations, something. On July 24th, 2023, Ms. McCabe told Mr. Nelson, the victim advocate, something. Okay, and then we got some more redacted information here. On December 8th, 2023, and look at this footnote number 8, again from his personal email account, another violation, D.A. Morrissey wrote to Tully and others bemoaning the AG's conclusion that Mr. Carney's conduct did not warrant criminal prosecution. So they're getting upset now. They're getting upset about this. On information and belief between August 9, 2023 and August 25th, 2023, so we're moving on now to August, Ms. McCabe, members of the Albert family, the MSP, and Morrissey, and or others met to discuss Ms. McCabe's latest demand for the DA to do something to stop Mr. Carney from reporting about her. On August 25th, 2023, D.A. Morrissey capitulated to the demands and threats of Ms. McCabe and the Alberts and decided to do something about Mr. Carney. So what was the something? Now, this is all leading up. So now on August 25th, 2022, what does he do? Something was D.A. Morrissey's video-recorded public statement, which press officer David Traub immediately disseminated to local and national print and television media. You all remember that video. Prior to issuing this ill-conceived public statement, with assistance from Canton Police Chief Helena Rafferty, and I'm wondering why he doesn't mention anything about the possible professional conduct issue here. But okay. With assistance from Canton Police Chief Helena Rafferty, Morrissey accepted input on the content of a statement from a person advocating for Ms. McCabe and the Alberts' interest. Mr. Traub informed the advocates that he sent Morrissey's statement to Dateline NBC and numerous other media entities. By issuing a statement on behalf of witnesses with interests that differed from his own, Morrissey allowed himself, the elected district attorney, to be exploited as a puppet whose strings were controlled by influential private citizens motivated to advance their self-serving agenda, which included silencing Turtleboy. So what was the pressure on Morrissey? Well, number one is that they're seeing perhaps some corruption in the DA's office, which maybe was concerning also on its own, but also he kept having these people, influential people, and this is what the motion is laying out, all these influential people, like the McCabe's and the Alberts, in his ear all day saying, do something, figure out something, get him to stop. So he tried to get the AG's office, and they weren't interested. So now let's see what happens next. So he issued this video, and everyone was supposed to listen to the video and then trust him and then just ignore Turtleboy now. Because, come on, how can Turtleboy know more than the DA's office? DA Morrissey's statement was a flagrant violation. Oh, there it is. Okay, Rule 3.6, the Massachusetts Rules of Professional Conduct. Well, there you go. Okay, forgot about that. Although he didn't name Mr. Carney in his public statement, Morrissey took subtle shots at him by attempting to discredit the reliability of information from the internet. Morrissey vigorously vouched for the credibility of Ms. McCabe and the Alberts, decried their victimization from Mr. Carney's witness intimidation, ludicrously decreed that Colin Albert did not commit murder. Remember that part? He said this all. Blatantly misled the public about Mr. Proctor's credibility, discussed the evidence against Ms. Reed, and implied that she was guilty. This latest effort by Morrissey to stem the snowballing criticism failed miserably. On September 3rd, 2023, in a group text, which included Morrissey, Tully, Buchanan, and others, Mr. Proctor, referring to Mr. Carney, probably in not a nice way, probably not in a complimentary way, but we don't know because it's redacted, said the quiet part out loud, asking something. Would be nice to know what he asked for. As it turns out, Mr. Proctor, something was prescient. In the aftermath of their futile public statements and after being repeatedly rebuffed by the DOJ and the AG, the Commonwealth played its only remaining hand, shut Mr. Carney up by prosecuting him itself. So they tried everything. They tried the statement. They tried everything, and nothing's working. So at this point, they finally realized, well, we're going to have to take matters into our own hands and charge him ourselves. And that is how this lays out, and it reads to show you all the lead up to what led to his witness intimidation charges. The Commonwealth unveiled an Aurelian plan in which they, the very people being criticized of Mr. Carney, weaponized the witness intimidation statute for the purpose of silencing his criticism of them. The court is no doubt aware, by the way, of Mr. Proctor's habit of crudely referring to people adverse to his position. At a minimum, the disgraced former trooper has separately made inappropriate remarks about Ms. Reed, two of her attorneys, a medical examiner, and Mr. Carney, as we all know from the trial. Within months, and this is still in the footnote number 10, within months, the out-of-control Commonwealth's abuse of the witness intimidation statute led it to investigate others with the temerity to publicly criticize the case against Ms. Reed. The MSP and Canton Police Department summons protesters outside of Chris Albert's pizza shop. In what became a national embarrassment, they sought witness intimidation charges against people who placed tiny rubber ducks. You know why? Because, as Alan Jackson said, if it talks like a duck and it walks like a duck, it probably is a duck. So that was the idea. So somebody placed tiny rubber ducks, and they charged them with, with witness intimidation on public streets of Canton. They investigated people for the content of the Facebook messages, which were critical of Miss McCabe and the Alberts. This colossal waste of public resources didn't result in a single conviction. On September 15, 2023, in connection with Ms. Reed's court appearance, Mr. Carney and a large group of her supporters loudly protested outside of the Dedham courthouse in support of her innocence. So that's September 15, 2023. Okay, now we have some more redactions here. On September 26, 2023, Morrissey recused his office and engaged Mr. Mello as a special prosecutor to handle the anticipated prosecution of Mr. Carney because Mr. Mello has a very strong record, which is what we went through yesterday, which we saw some of the times that he was disciplined. But, you know, Mr. Mello, he's got to be the one to be the special prosecutor charging. I think they showed in this document, they had an exhibit which showed, I think, his work on, was it maybe 3 months? I think October through December. And Mr. Mello got paid over 70 grand for that. So that's an exhibit to this motion as well. So I don't know if Mr. Mello and Morrissey are friends. I don't know. I'm not going to speculate at all, but his choice of Mr. Mello was definitely interesting as a special prosecutor, given his record and okay, well, whatever. Although the DA's recusal indicated Morrissey's appreciation for the clear conflict that would arise from his office prosecution of a journalist who criticized the DA, the MSP, which faced the exact same conflict, didn't recuse itself from the Carney investigation. Nah, they don't need to recuse themselves. After all, this conflict is only for the DA's office, not the MSP. Tully, a frequent target of Mr. Carney's criticism, remained the lead investigator. Mr. Proctor recently had referred to Mr. Carney as something and something, and if I had to venture a guess, these are not probably brilliant and good looking. I just had to venture a guess. That's not probably what he wrote there, but it's redacted, so I can't tell you what he said. but you can use your imagination. And Sergeant Buchanan and also regular targets of Mr. Carney continued to participate in the investigation and later became named victims in the indictments against him. Now, Mr. Proctor and Sergeant Buchanan testified that they were intimidated by Mr. Carney. Both indictments were dismissed by the court on May 19, 2025. And we have to go down to the next footnote. In particular, the dismissed indictment related to Sergeant Buchanan illustrates the Commonwealth's lack of good faith in prosecuting Mr. Carney. To think that they're going to use that to throw this charge in there shows everything, right? Your weakest link. That kind of shows you exactly what everything's about. So what happened with Buchanan? That charge involved a September 15, 2023 video recorded incident in which Mr. Carney questioned and then criticized Sergeant Buchanan as he left court and walked to his car. It is obvious that Sergeant Buchanan wasn't intimidated. He calmly entered his vehicle, rolled the window down, and extended his middle finger as he slowly drove away. Now, you don't know that is actually the way that you say goodbye when you're very terrified. Maybe if you get a dictionary and look that up, if you have a Webster's dictionary, you can find that. But that's what he did. Nevertheless, Sergeant Buchanan testified that Mr. Carney's conduct absolutely intimidated him. Sergeant Buchanan didn't even prepare a report on this non-incident until November 2nd, 2023, several weeks after Mr. Carney had been arrested. So your weakest link shows the strength of everything else. All right, without more, the MSP's failure to recuse itself and the DA's failure to insist on it in the face of such a blatant conflict of interest and actual bias caused him to question the motivation of the Commonwealth and entirely discredits the case against Mr. Carney. On September 28, 2023, Chris Albert unsuccessfully petitioned for a harassment prevention order against Mr. Carney. So there's some more harassment prevention orders that are applied for and denied against Mr. Carney. The court denied Mr. Albert an order, concluding that his allegations did not constitute true threats or harassment under the law. Notwithstanding his supposed recusal from the Carney investigation, on September 29, 2023, Morrissey, from his personal email account, contacted several high-ranking Massachusetts judicial figures, including the judge who denied Mr. Albert a protective order the previous day, demanding that a Stoughton court clerk be investigated in connection with Mr. Carney's awareness of Mr. Albert's application for a protective order. So he found out about it. So therefore, he demanded that whoever shared it should be found out and, spoken to. Now, he's supposed to be recused from this investigation. He's not supposed to be doing anything about this investigation. So what are you doing? Well, maybe that's why he used his personal email address. I don't know. That's just all speculation. But he did. He did ask for it. Connection with Mr. Carney's awareness of Mr. Albert's application for a protective order, which Morrissey claimed he had no right to know about. Morrissey was awarded the investigation he sought. On October 31st, 2023, 3 weeks after Mr. Carney's phones were seized by Tully, a Stoughton court official presented the target of the investigation with pages from an extraction report from one of Mr. Carney's seized phones. Despite irrefutable proof that at least one of Mr. Carney's phones had been extracted by Tully, or with his knowledge, Mr. Mello falsely represented on November 28th, 2023, that the MSP had not perused the material. It is in pristine form located on the defendant's devices. On November 10th, 2023, recused Morrissey from his personal email account again, emailed AG Andrea Campbell. He acknowledged that the AG refused to prosecute Mr. Carney, but he again urged the AG to take some action against him. Come on. Can't you do something? Can't you figure out something that we can charge him with? Now, this is not selective. This is not targeted prosecutions. This is not, this is America after all. This is not a DA trying to figure out some sort of crime to stick to somebody and begging the AG to get involved. Once again, the AG declined to prosecute or take any other action against Mr. Carney. Now we get into Ms. Peter. Ms. Peter worked for Mr. Carney from September 2018 until February 2020, when Mr. Carney terminated her employment after he caught her stealing from him. Since Mr. Carney terminated her, Ms. Peter's unhealthy fixation on needling Mr. Carney seemingly has dominated her life. It recently resulted in her being permanently stained with a criminal record. So she does have a criminal record. She pled to something. Ms. Peter, I didn't say here what she pled to, but it's if you click the link, you can see exactly what she pled to. Ms. Peter's behavior has resulted in additional criminal prosecutions and the issuance of numerous protective orders against her in favor of Mr. Carney and others associated with him. Ms. Peter's disdain for Mr. Carney has led her to engage in fraud, forgery, the manufacture of evidence, and other acts of dishonesty for the purpose of harming Mr. Carney. In March 2020, shortly after Mr. Carney fired her for theft, Ms. Peter engaged in a harebrained scheme where she forged documents and fraudulently filed them to advance her position and harm Mr. Carney in connection with a petty YouTube copyright dispute. Ms. Peter brazenly sent YouTube what she falsely represented was a federal copyright civil complaint dated March 24, 2020, that she filed in the District of Massachusetts. In a case she captioned Catherine Peter versus Aidan Carney, Worcester Digital Marketing. Probably messed up that first word, but anyway. In fact, the ostensible complaint Ms. Peter filed was a forgery, and there was no federal lawsuit involving Mr. Carney and Ms. Peter. It was an absolute forgery. Unaware of Ms. Peter's dishonest nature and penchant for scheming against Mr. Carney, YouTube relied upon her fraudulent documents and false representations to her benefit and Mr. Carney's detriment, and initially ruled in her favor. So she tricked YouTube. Ms. Peter committed fraud by going online and accessing a legitimate civil complaint filed in a 2013 federal copyright suit from the District of Massachusetts. She altered the caption and other information to make it appear as if her fraudulent documents were authentic, represented it as her legitimate complaint, and filed it with YouTube. Ms. Peters' criminal scheme was exposed by her ignorance of the federal court practice. She failed to change the index number when she doctored the legitimate complaint, which meant that her ostensible 2020 complaint contained a 2013 index number. You understand that? That means that 2013 means that was the year that this is filed. Okay, if you filed something in 2013, it cannot be about something that happened in 2020, unless you know the future. So that's the mistake that she made. She left on the 2013 index number. On November 20th, 2022, in an online interview, Ms. Peter admitted that she submitted the forged complaint with the intent to defraud YouTube because she hated Mr. Carney. So this is not that she doesn't admit that, she admitted it. And you click on that link and you can see where she said it. Despite engaging in a dishonest scheme, Ms. Peter reasoned that she was trustworthy because she admitted her wrongdoing. Ms. Peter remains subject to prosecution in Massachusetts for forgery until March 24th, 2026. And that's just a little snippet for the court to understand that that was fraud, and she's remained subject to prosecution in Massachusetts. So if Massachusetts took these things seriously, they would prosecute her, right? That's what you would think, and that's what the suggestion here is in this motion. Ms. Peters' self-serving defense of her trustworthiness didn't last long. Within months, she again succumbed to an impulsive urge to harm Mr. Carney and sent him an anonymous email filled with defamatory and false information about Colin Albert and Chris Albert, hoping that Mr. Carney would publicly harass the Alberts with the false information she fed him. So that was the email that we showed you earlier. Ms. Peter was acutely aware that if Mr. Carney publicly accused Colin Albert and Chris Albert of criminal activity, it likely would lead these Reed case witnesses to claim that Mr. Carney witness intimidated them by causing them emotional harm. On May 28, 2023 at 3:30 p.m., concealing her identity under the alias Maya Rose, Ms. Peter shamelessly emailed Mr. Carney that Colin Albert was a drug dealer and that he was responsible for killing Mr. O'Keefe. Ms. Peter lied to Mr. Carney that Chris Albert knew his son moved drugs with DNA Pizza, this is what we read in the email earlier, and that the whole Albert family made money from Colin's drug operation, which probably explained why Brian Albert covered up Mr. O'Keefe's death. Ms. Peter's deranged scheme included presenting Mr. Carney with fabricated screenshots she created and which purported to show Maya and Colin Albert discussing drug deals. And we showed you those text messages. In March, look at this footnote here. In March 2025, Colin Albert and Chris Albert's complaints did result in further witness intimidation charges against Mr. Carney. According to the Alberts, they suffered emotional harm after they viewed DNA camera footage of Mr. Carney, who had been socializing with friends next door at C.F. McCarthy's, clowning around while looking at D&E's security camera. So I think you all remember those videos. Mr. Carney's comments were unlawfully intercepted by a second camera. Remember, it's unlawful to record somebody else without their consent. That was what the first part of the grand jury proceeding was about with Scanlon. But now you got Chris Albert doing it, and Mark Better was wondering why nothing was done about that. The Alberts claimed they were intimidated, even though they weren't inside D&E, and viewed the footage on their phones from a different location. So they saw it from a different location and claimed that they were intimidated. Ms. Peter falsely told Mr. Carney that Colin Albert talked about harming John because he believed Mr. O'Keefe was investigating his drug dealing, just as Ms. Peter intended during his May 28, 2023 live show. So here you go. Mr. Carney told his audience that he received an anonymous email alleging that Colin Albert was a drug dealer, and this served as a possible motive for him to kill Mr. O'Keefe. Mr. Carney read the email Ms. Peter sent him and indicated that he would investigate this information. He cautioned his audience that this was new, unvetted information, and he did not vouch for its accuracy or state that it was true. Importantly, after investigating, Mr. Carney later stated that this information was not credible. On May 29, 2023, during her own live stream, Ms. Peter gloated about her disgraceful conduct, which she oddly thought harmed Mr. Carney and made her look good. Amused by her little fib, she proudly admitted, and you got to love this writing, admitted that the defamatory and false information she provided Mr. Carney about the Alberts was 100% a fabrication out of my mind. Ms. Peter conceded that her conduct was damaging to Colin Albert and Chris Albert, but rationalized it was because I sent this just to F with Aiden. Ms. Peter threatened Mr. Carney, warning him that he should fear her. She issued a call to arms and urged her trolls to send Mr. Carney more false information, which she would then share with his alleged victims. She bragged, I know that bad things are happening to you right now, Aiden, and you're probably thinking that it might be me, but it is me. Just so you know, every single annoyance, every single horrible thing that's happening to you right now, yeah, I've done it. Call the police, you beat. In other words, just as she did in her 2020 YouTube spat with Mr. Carney, Ms. Peter demonstrated the ease with which she lies, and in this instance, intentionally cause emotional harm to prosecution witnesses if it helps her F with Aiden. And this is the person who the police are relying on, feeding them information, and assuming that the information is not doctored, assuming that it's accurate and reliable and credible. Ms. Peters' defamatory stunt apparently did cause emotional harm to Colin Albert and Chris Albert. On August 1st, 2023, Chris Albert specifically cited something. So apparently, what she did actually harmed Chris Albert, or was it Colin Albert? Chris Albert. Was it Colin Albert also? And Colin Albert. So again, we don't know what's written in these because it's redacted. Just as Ms. Peter intended, Mr. Albert assuredly blamed Mr. Carney for the bogus drug dealing allegations, entirely ignorant to the fact that it was his supporter and advocate, Ms. Peter, who saw him and his son as expendable collateral damage for her false flag operation to harm Mr. Carney. Within weeks of Ms. Peters' cruel and defamatory attempt to amuse herself at the expense of the Alberts and her call to arms, unleashing her trolls on Mr. Carney, Tully and Mr. Mello willingly relied on her as a primary source for gathering evidence to use during the grand jury proceeding against Mr. Carney. On information and belief, for years, Ms. Peter has spent several hours a week online monitoring and cataloging Mr. Carney's content, mining for material to use against him. You got to love this writing. Ms. Peter has no... Did I say that before, by the way? I'm not sure if I mentioned it, so I think I should say it again. You got to love this writing. Ms. Peter had no public interest or stake in the Reed case and no association with any witnesses in it until Mr. Carney began supporting Ms. Reed's innocence. Naturally, once Mr. Carney started to support Ms. Reed, Ms. Peter became a self-styled advocate for Ms. McCabe, the Alberts, and the O'Keefes. And again, I have no idea if there's any sort of relationship there at all. No idea at all. But, you know, you would think if someone's going to say something about your kids like that, I'm not sure if they're going to want to cozy up with you. But let's continue. She became a self-styled advocate for the Miss McCabe's and the Alberts and the O'Keefes and sought to foster relationships of convenience with others who hated him, including Lindsay Catani, who shortly after meeting Ms. Peter became the alleged victim in the 2024 witness intimidation indictment against Mr. Carney, what we call the alleged victim. On September 13th, 2023 at 3:34 p.m., Ms. Peter publicly bragged that she had archived a purportedly illegal recording made by the retard, Mr. Carney, of his conversation with Stephen Scanlon, a private investigator who was tangentially involved in the Reed case in early 2022. Ms. Peter claimed she forwarded the recording to the MSCP. Take a look at this, this footnote. Nothing encapsulates Turtleboy derangement syndrome, an affliction, he just made this up, an affliction which causes people who turn on Mr. Carney, including Ms. Kanani, to engage in irrational behavior more than the several people who protested in support of Ms. Reed's innocence and then flippantly switched sides and protested for her conviction solely because of their hatred for Mr. Carney. After she accused Mr. Carney of intimidating her, Ms. Katani became such a rabid advocate for Ms. Reed's guilt that on July 1st, 2024, clad in the same Justice for John O'Keefe shirt as Ms. Peter, she appeared with Ms. Peter on a live interview with Core TV. So you can go click that link and you'll see the interview. Now, the interview is Julie Grant interviewing Kate Peter and Linda Gattani, supposedly, I'm assuming that's, if this is accurate or not, but next to her. And I don't know, Linda Gattani didn't say anything. Like, it was just, she was just there, I guess, maybe for moral support. I'm not sure. But she was just there sitting next to Kate Peter, and Kate Peter did all the talking, but she was there wearing this t-shirt. So what's it called? Turtleboy derangement syndrome. And they, by the way, if you look at these, one of these links also, I think the Turtleboy derangement syndrome, if you look at those links, you'll see some pictures, and I think probably Turtleboy's got this, where you've got a picture of the person when they're free Karen readers, and then next to them, you have the picture when they switch sides because of their, I guess, hatred or alleged hatred for Turtleboy. On information and belief, on September 13th, 2023, at 4:23 p.m., Ms. Peter created a version of the recording and sent it to Tully in a private link. So somehow, I don't know how, but somehow she got this recording. And then she sends this recording to Tully. Now, what do you know? There's some parts of the recording that are not clear or whatever. I mean, they're cut. Some of the recording is cut. November 28th, 2023 transcript. Tully testified he had been sent a video of the Scanlon recording. The person who it was sent to, she stated it was a private link, so it was not available for public distribution. An audio copy of the recording that Ms. Peters sent the MSP on or about September 13, 2023, I think we played this yesterday actually, wasn't provided to the defense until August 8, 2025. Can you believe that? This wasn't provided until August 8th, 2025. Was it like 10 days ago, 11 days ago? The version of the recording provided to the defense doesn't include the beginning of the recorded call, skips and repeats. It is clearly edited. The defense hasn't been provided with a copy of the email or any communication in which Ms. Peter provided the Scanlon recording to the MSP. So how did she provide that to Tully or to the MSP? Did she drop it off herself? Or did she send it as part of an email, which is more likely? And if she did, where is that email? I want to see that email, but we haven't been provided it. And where's the entire recording? And why would you rely on this recording, which is very obviously edited and cut? Okay, some more redactions. And then here's an important part. Either ignorant or dismissive of Ms. Peters' own criminal conduct and woeful credibility, Sergeant McKinnick praised Ms. Peter, thanking her. On September 29, 2023, now Buchanan becomes known by a first name basis with Ms. Peter. And some more redactions. On September 29, 2023 at 3 p.m., Ms. Peter tweeted October 10th, he knows the deal. Okay, so this is September 29th, 2023 at 3 p.m., Ms. Peter tweets October 10th, he knows the deal. Now, what do you think is going to happen on October 10th? In this case, 11th. Well, somehow she knows this. How does she know this? How would she know anything that's going to happen October 10th? Unless she's working hand in hand with the MSP, with Buchanan, or other people associated with them. In response to another post asking her when Mr. Carney would be subpoenaed. On information and belief, Ms. Peter reference to he knows the deal indicates that the MSP told her several weeks before Mr. Carney's arrest that they intended to arrest him on October 10th, 2023. On September 29, 2023 at 4 p.m., Sergeant Buchanan forwarded his email correspondence of September 27th and 29, 2023 with Ms. Peter to somebody, which is redacted. Okay, some more emails that are redacted. Responses, okay. Almost 2 years later, and despite numerous specific demands related to Ms. Peter's relationship with the Commonwealth, the defense hasn't been provided with any notes, reports, or videos related to Ms. Peter or the private link she sent Tully on September 13, 2023. So they're still asking for this and they're not getting it. For months prior to the November 28, 2023 commencement of the grand jury proceeding, Tully, Buchanan, and Proctor were aware of Ms. Peter's unstable obsession with Mr. Carney. So they knew about this relationship, if you want to call it. I mean, whatever you want to call it. With her obsession, I guess that's a good way to say it, with Turtleboy. As experienced detectives who had been investigating Mr. Carney since mid-2023, the MSP knew or should have known of numerous red flags which adversely impacted Ms. Peters' credibility, including her eager insertion of herself into their investigation, her personal animus towards Mr. Carney, which gave her a clear motive to falsely accuse him of a crime, her insertion into Ms. McCabe's orbit, and most importantly, her prior history of falsifying evidence against Mr. Carney. She's done this before. Like, is there not a bigger red flag if somebody has already falsified something against another person that maybe they may do it again? Is that maybe a chance? Indeed, given their constant review of social media as the means of acquiring evidence against Mr. Carney, the DA and MSP must have been familiar with Mr. Carney's March 30th, 2020 article detailing Ms. Peter's fraud in connection with their YouTube copyright dispute, right? That fake complaint. And Ms. Peters' May 29, 2023 live stream where she admitted falsifying evidence about Colin Albert and Chris Albert to goad Mr. Carney into smearing them. Mr. Carney was arrested on October 11th. What a coincidence. Kate knew something was going to happen October 10th, and then he was arrested October 11th, just one day after Ms. Peter publicly announced weeks earlier. MSP audio transmissions from immediately before Mr. Carney's arrest reveal that the arrest team, a fugitive unit which included Tully, heard from KP. It was the same thing from yesterday, 2 older kids getting on around the same time, but it was 8:30. And information to believe, KP referred to Ms. Peter, Catherine Peter, and she helped the MSP coordinate Mr. Carney's arrest by monitoring him beforehand. So they were using her to monitor him. That's the allegation here. Look at 17. Ms. Peter has a history of surveilling people to create chaos for them. She and Ms. Gattani discussed spying on Ms. Reed and the members of her legal team at the Omni Seaport Hotel in Boston. She also has shared surreptitious photos of Mr. Carney and others socializing at the Hillside Pub in Canton on March 4th, 2025. Ms. Peter attended Mr. Carney's October 11, 2023 arraignment in Stoughton District Court. She has testified that she went to meet with Mr. Mello and that she was a potential witness against Mr. Carney. Shortly after Mr. Carney's arrest, Ms. Peter, with the blessing of Mr. Mello and Detective Tully, became an integral part of the prosecution team. On October 25th, 2023, Ms. Peter emailed Tully that she and her team were something, and we don't know what it says. To this day, the DA hasn't informed the defense of who, if anyone, served on Ms. Peter's team. Who was part of the team? Was it just you and Gattani? Who else is part of that team? Well, they didn't tell us. Ms. Peter sent Tully a something, which she, again, blocked out, wherever she believed there was an evidence of a crime. She advised Tully something. Okay, and these are all redacted. Almost 2 years later, the defense hasn't been provided with information Ms. Peter provided to Tully in those events. On November 1st, 2023, Ms. Peter emailed Tully with the subject line something. And again, these are all redacted. And again, almost 2 years later, the defense hasn't been provided with the video file and any response by Tully to Ms. Peter's questions. According to Tully, he relied upon information Ms. Peter provided him before he edited Mr. Carney's YouTube episodes. On November 26, 2023, just 2 days before Mr. Mello commenced the grand jury presentation, Ms. Peter emailed him something right before the grand jury. On November 26, 2023, Mr. Mello's response to Ms. Peter proved that he opened private links sent to him by Ms. Peter. So you see, this is something that's redacted that we can't see, but this is what Bettero is representing, that you see clearly that Mello actually opened the private links. And if he opened it and if he saw it, then he had a duty to turn it over. And if now he can't turn it over because it was deleted, then this case has to be dismissed. It's a clear call of a Brady violation. And there's extreme prejudice because it's deleted now. You can't just say, sometimes the court would just say, okay, well, now you have it. Now you have the information. So you've been complaining to me for 2 years that you didn't get something. Okay, well, now you have it. What do you want from me now? You want to adjourn the trial? Okay, we'll do that. Which is why a lot of times Brady violations will result in mistrials, but it won't result in dismissals. But in this case, if Mello actually saw the link and he saw what was provided to him and they don't have that information anymore, then you cannot just say, well, it wasn't important. That's not for you to decide. You got to turn it over. And if you don't, then the case has to be dismissed. Ms. Peter's November 26, 2023 communication with Mr. Mello conclusively establishes that Mr. Mello outsourced investigative work to her, discussed strategy with her, and was aware that she edited Mr. Carney's content with her own editorial slant and bias, and that he provided or reviewed private links she sent him 2 days before the grand jury proceedings started. This is a very active participant in this investigation. Again, according to these documents, Lieutenant Fanning has testified that Ms. Peter reported things to the MSP that they can't find or document. In December 2023, as part of her plan to coax Ms. Gattani into bringing witness intimidation charges against Mr. Carney, Ms. Peter told Ms. Gattani that she had something, and this is all blocked. But again, showing about the communications between, that there was something going on. They got some sort of communications eventually, but there's still a lot missing, a lot. On February 26, 2024, Ms. Peter left Mr. Carney a crude and harassing voice message. Again, this is all based on this motion. That's where I'm basing my statements on. On February 26, 2024, Ms. Peter left Mr. Carney a crude and harassing voice message, gloating about her importance to the Commonwealth's case against him. And this is a portion. I think it's just a portion of the voicemail that she left. If you want to see the entire voicemail, you could. It's Exhibit SS. Just don't have any kids around. And it says, hey, I'm going to skip some of the profanity here. It's Kate Peter, Krusty Panties. Every time you get a blocked number, it's not Lindsay or LG or anyone else. It's me. And I just want to let you know that when you go back to jail, I had absolutely everything to do with it. because you are a dumb MFer. I am going to get the best of you. You are a bad person, and everybody's going to see it. Have a nice day. By the way, Karen Reed wants nothing to do with you. Go F yourself. B, I meant it. And I'm not, maybe that is the entire message. I'm not sure. But yeah, so very clearly that she has real animus against him, and she's the one that's aiding the prosecution. In March 2024, and this is who they're relying on for their evidence. In March 2024, Ms. Peter boasted under oath in Carney versus Peter that Mr. Carney is angry and upset with me because I have been cooperating with the prosecution and giving them information on him. He can blame me for all his problems because I am furnishing information. So that is everything about Peter. Now, what's the point of that in this motion? Well, the point is just to lay out everything and to show how ridiculous this charge is in the first place. You know, they're relying on all this information. But really what's important in terms of a legal sense is really just all the information that there is between the two of them, and they don't have it all. And some of it has been deleted and is not accessible anymore. That's a Brady violation. So a lot of that's important for the court to know. A lot of it's important to lay out the context for this and to lay out the timeline and to show how this one person was obviously very personal animus against Turtleboy, and that she's doctored and falsified complaints before to her advantage, and that she's not been prosecuted under Massachusetts law for that. And this is who they're relying on. I mean, it's just, you see the problems with this. And yeah, all right, let's move on now. Tully prepared and signed the charging documents filed against Mr. Carney on October 11, 2023. As a special prosecutor in charge of the prosecution, Mr. Mello was familiar with the contents of the charging documents and the evidence against Mr. Carney at the time of his arrest, which was almost 7 weeks before Mr. Mello elicited testimony from Tully before the grand jury. Mr. Mello billed taxpayers for only 56 hours of work. This is where you can actually see how much Mello got paid for this from October to December, I think, of 2023. So just for those 3 months, it was over 70 grand. And that was it was 2023. So how much more have taxpayers paid Mr. Mello or Cosgrove now for this? Mr. Mello billed taxpayers for only 56 hours of work performed during October 2023, even though commencing on October 4th, 2023, and on each and every day thereafter, including weekends, and this is a quote from his billing statement, and all legal holidays, I've devoted an absolute minimum of 4 hours each day, and frequently 12 or more hours a day. So basically, he's getting paid, I would assume, to watch Turtleboy. That's what I would assume. I mean, well, you know, there may be some other work also, but you know, he's probably has to keep tabs on Turtleboy. So he's watching the show. You all watch the show for free. Maybe you give a super sticker or a turtle chat or whatever. But so you pay, but he actually gets paid. Nice job. Which meant that before Mr. Mello elicited testimony from Tully in the grand jury proceeding, he worked more than 232 hours on Mr. Carney's case. So he worked 232 hours on Mr. Carney's case before the grand jury proceeding. That's a lot of work. What were you doing for 232 hours? Which was rubber stamped, and he got paid, by the way. From October 2023 through December 2023, Mr. Mello spent more than 700 hours of time on this matter. His services included, but were not limited to, reviewing some 8 months of daily internet posts and blogs associated with this matter. This is what he was doing. He was getting paid by the taxpayers of Massachusetts 70 grand, which he claims was nice of him, because really he worked over 700 hours for watching and reading Turtleboy. I mean, that's a nice plug for Turtleboy. You know, someone's willing, you know, to have somebody else watch him and get paid for that much money. That's nice. Okay. Anyway, reviewing some 8 months of daily internet posts and blogs associated with this matter, coordinating efforts with investigators, drafting court filings, and making presentations to the grand jury. You know, no one's getting paid to watch my stuff, I don't think. I hope not. The charging documents in Mr. Mello's billing records reveal Tully's and Mr. Mello's familiarity with Mr. Carney's online videos and written articles. Tully accurately cited names of specific episodes, exact timestamps, and exact quotes within them. So in the charging documents, they were familiar with his episodes. They were familiar with his written articles, which would also suggest that they were familiar with how he labeled them. For example, Tully accurately named the titles of 3 episodes. Turtleboy Returns to Canton, Breaking Karen Reed defense files motion to recuse. Colin Albert drops out of school. Brian Higgins flipping. Is the end there? So those are the titles that Turtleboy named those shows, and Tully named them correctly initially. Tully repeatedly referenced numerous other unnamed episodes, citing and quoting from them in precise detail. Tully noted that Mr. Carney's episodes are publicly available for viewing without being a subscriber or follower and have been archived and investigated. So you don't need a private link. You don't need Kate Peter to send you this stuff. This is publicly available, even if you're not a subscriber. Can you believe it? Can you believe it? Even if you're not a subscriber, you can watch all this YouTube content. In fact, you're probably watching this, and many of you may not be subscribers. So what you should do, it's free after all, is just hit the subscribe button for Brother Counsel. We got to get to 50,000 already. All right, moving on. Thus, it is indisputable that before Mr. Mello elicited testimony from Tully during the grand jury proceeding, both men knew the actual titles, length, and content of Mr. Carney's YouTube episodes. The public availability of Mr. Carney's content and Tully and Mello's familiarity with it means there was no reason for the Commonwealth to consult with or seek Ms. Peters' input on what evidence should be presented to the grand jury. I mean, this is what Mello was paid to do, right? He's being paid whatever how much was, 70 grand, or maybe this is before then, to watch all this stuff. So why would you rely on Kate Peter? Watch it yourself. Decide what's important for you yourself. You're getting paid for it after all. You're getting paid to watch YouTube videos. So there's no reason to consult with or seek Ms. Peters' input on what evidence should be presented to the grand jury, or to clip, edit, and rename Mr. Carney's episodes and then conceal the actual episodes and their accurate information from the grand jury's consideration. Ms. Peters' communications with the Commonwealth provide additional proof that Tully and Mr. Mello worked hand in hand with her in gathering and editing evidence for use in the grand jury proceeding, and intended to deceive the grand jury by intentionally presenting a false and misleading description of Mr. Carney's episodes, right? That's one of the big, huge, I shouldn't say big, it's huge, monumental problems with the grand jury. Okay, well, guess what? And then we get into the flawed grand jury presentation, which we happen to have covered already yesterday. So we got through the entire motion. This is all in the affidavit or / motion that Mark Betterow filed. There's still a memorandum of law, which again reiterates a lot of these same allegations. It just uses the case law to show why there's problems there. So I can tell you there's problems there. I can tell you that there's problems with the grand jury presentation, which is what we went through yesterday. When you rename and cut out the context of some of these videos, then that is a serious, serious problem. Thank you very much, Ellen Victoria Olson for becoming a new Brother Counsel member. And I'm just going to give a few seconds. If anybody has any more questions or any questions about what's going on or any questions at all, we can take them now. And I'll just hang out here for a couple more minutes before we call it a day on this wonderful Friday and nice weekend. And by the way, next week, in case you're following me, next week, there's a Jewish holiday that's going to go on Tuesday and Wednesday. I am not sure if there's going to be a show Sunday or Monday. There may be a show Sunday or Monday. We'll see. We may be working on it. But Tuesday and Wednesday, I'm going to be out because that is a Jewish holiday, and there's going to be a lot of Jewish holidays coming up. So we'll see what happens. We're going to have to figure it out. One Tuesday, Wednesday, and the next week is Thursday, and then we have some more coming up. But there's some days in between, so we'll be able to continue with some of the content. Tiff says, Normal Mom, by the way, Tiff changed her name to Tiff/Normal Mom. I love to get paid to watch Turtleboy. Wouldn't that be nice? Wouldn't that be nice? Martha Ivy, is there more to go over? So there is, like I said, there's this memorandum of law, which basically is just all the basis in the law. And, in case you don't trust me that you can't do some of these things in the grand jury proceedings, like you can't have an opinion. You can't elicit opinion testimony in a grand jury proceeding. You can't ask the police officer, in your view, did Turtleboy have intent to intimidate witnesses? That is an ultimate question for the jury. So that was That was one of the problems. I mean, we can go through some of the case law also, but we're not going to do that today. But I'll take a look at it and I'll see if there's anything interesting. I always do. But I mean, like this is pretty simple. It's pretty clear what happened. And again, at the very, very least, there has to be an evidentiary hearing. There has to be an evidentiary hearing about this stuff. All right. Okay. Well, I guess everything is so crystal clear when you come to Brother Counsel. There's no question. So that's great. All right. So we'll see what happens next week. There may be something Sunday, Monday. Maybe. I'm not sure. We're going to have to see about that. But if you're sitting and watching this now, I'd appreciate it if you just hit the subscribe button, hit the like button. It's free, and it just helps the channel grow. And that's what we need to do here so that more people can get the scoop, get the legal analysis. Katie Cat says, by the way, no questions, but a big thank you for hanging out and keeping us up to date on Turtleboy. And yeah, we'll have to see when this hearing happens. We'll have to see what the response is. Hi, Brother Counsel. You may have mentioned, but you okay? Looks like bruises under your eye. Which eye? This eye? This eye? This eye? I don't think I got any bruises. I mean, I was playing hockey this morning, but I don't think I got any bruises. So I think we're okay there. Will Cosgrove be at the next Turtleboy hearing if he is disqualified? Well, he's not disqualified quite yet. Cosgrove, the reason why they want to, he wants to, first of all, understand this. He wants to disqualify Mello. That's number one. Mello's got to be disqualified. He's a witness. Cosgrove's not a witness. The issue with Cosgrove is that he's being sued by Gattani. And being sued by Gattani can create a conflict of interest for him. So that's why he may have to also be disqualified. But as we sit here today, Cosgrove is not disqualified. So he will be at this next hearing. He probably is going to be responding to this motion as well. Now, we know we have a hearing coming up, but I don't think that there's going to be, this issue is not going to be at the next hearing. So they're going to need some time to respond to this. And then we're going to have another hearing on that. Stacy, do you think they'll dismiss the charges? They should. They should dismiss the charges. The judge should dismiss the charges. And again, at the very least, you want to give everybody the benefit of the doubt, then fine. Have an evidentiary hearing. Get everybody on the stand, say what happened, and let's talk about it. That's the very least that should happen here if you're not going to dismiss it outright. I would argue, just by the fact that they changed the titles and clipped them and give opinion evidence, that's not dispute. That's not a dispute, right? So then that alone should be enough for a dismissal. Now, if you want to discuss more about it, then okay, we'll have an evidentiary hearing about it. Bluegrass Girl says, just pay me to watch Brother Counsel. Any takers? Anybody want to pay Bluegrass Girl? She's right here. All she wants is a couple bucks to watch Brother Counsel. Danielle, it's very scary living here in Massachusetts. I understand. And, but this is all shedding light on what's going on, and hopefully everyone's going to get their act together, and it'll be all better. That's what we need to, you have to shed some light on this and show everybody what's going on there. And it can be scary. Now, on the other hand, people I know are very upset about all their tax dollars going to this. And now the next thing is that maybe Karen Reed's going to get indicted for witness intimidation, which is why they don't want to give back her phones. So they're going to now spend all this money on a special prosecutor again to prosecute Karen Reed for witness intimidation charges. I mean, I assure you, that would be the greatest gift to Turtleboy. The greatest gift to Turtleboy is to charge Karen Reed. If you want to absolutely destroy your case against Turtleboy and have any chance, just charge Karen Reed with witness intimidation also. Have them as co-defendants. That would be just great. Have Alan Jackson there. Have two shots at cross-examination of these witnesses. Two lawyers. Have Mark Betterow cross-examine the witnesses, and then have Alan Jackson cross-examine the witnesses. So, all right. Okay, guys. Well, everybody have a wonderful, wonderful weekend. And thank you all for joining us today. and we'll see what happens next week. We'll keep you posted. So just definitely, follow me on Twitter, and I'll post any updates or anything that's going on. And again, just like and subscribe. So have a great weekend, everybody, and we'll see what happens next week.